respected seniors, respected members of the bar, company secretaries, chartered accountants, and my dear friend. Good morning. Welcome to the Lex Ponder e-lecture series to be addressed by Shri Neeraj Kishan Kaul, Senior Advocate, Delhi High Court, on a very important and contemporary subject that all of us have been discussing over the last few weeks. Shri Neeraj Kishan Kaul is one among the most respected and distinguished senior members of the Delhi Bar. He completed his post-graduation in Cambridge University in law and started practice in the Delhi High Court. He was designated at a very young age as a senior lawyer and has practiced in almost all areas of law and served as the Additional Solicitor General in the Supreme Court also. He is known for his quick grasp, deep acumen in law, and immense practicality. And on a personal note, he is known for encouraging younger members of the bar. On behalf of NKM Law Chambers and everyone, I thank Shri Neeraj Kishan Kaul for accepting our invite. So thank you very much. The topic for the day is the Insolvency Bankruptcy Code that has been a trailblazer legislation over the last few years from 2016. It has changed the entire framework in which the insolvency law has been operated. It has paved way for so many resolutions to take place. In some cases, companies that were winding up petitions in the High Court that were pending on for several years have certainly been disposed of in the new regime within a specified timeline. We have had bad loans and bad debts not increasing. And the Insolvency Bankruptcy Code has certainly acted as an impetus in the entire industry. But now in these tough times, as COVID is one among the biggest pandemic that has haunted us, it has become necessary to suspend the Insolvency Bankruptcy Code. And all of us would know that a couple of days back, the IBC has to suspend it for 6 months with a specified cutoff date. And it has also been stated it can be extended up to a year. Many of us fear that whether the cure is worse than the disease. And that is exactly the point that the speaker for the day would be addressing upon. Suspending the Insolvency Bankruptcy Code. Is it a predicament or a panacea? I leave it to Shri Neeraj Kishan Kaul to take over. Sir, Neeraj sir, we are waiting for you to deliver the insights that sir feels would be very relevant on the subject. Thank you very
much. Thank you, Naveen and the NKM Chambers for inviting me. And a very good morning to this very distinguished audience from the great city of Chennai. It's a very interesting topic. And I'll try and restrict my opening comments to about 15-20 minutes. And I thought it'll be far more engaging if we have a question-answer session after that. So as far as the Insolvency and Bankruptcy Code is concerned, it completely reconceptualized the framework for insolvency resolution in India. It actually provides a mechanism for insolvency resolution of debtors in a time-bound manner to enable maximization of value of assets with a view to promote entrepreneurship, availability of credit, and balance the interests of all stakeholders. When the code was enacted, it was hoped that it would provide a consolidated insolvency framework that would give a certain certainty to the process, time and outcome to creditors, borrowers, and other market participants. In fact, the BLRC report specifically mentions that one of the objectives of IBC is to provide impetus to the bond markets. And the same report in its recommendations also says that it laid considerable focus on the empowerment of workmen and other stakeholders. The Supreme Court in Swiss ribbons some observations which are of relevance in terms of the success of this code from the time it was enacted, said, and I quote, "We are happy to note that in the working of the code, the flow of financial resources to the commercial sector in India has increased exponentially as a result of financial debts being repaid." And then the Supreme Court went on to say, "The defaulter's paradise is lost. In its place, the economy's rightful position has been regained." Now, this was the object with which the code was enacted, and no doubt it achieved considerable amount of success. Now, with the pandemic as it came in, the finance minister announced that an ordinance would come in, which finally did, and that brought in Section 10A with its proviso and effectively suspended initiation of proceedings under Section 7, 9, and 10 of the code. Now, as far as the intent of this ordinance is concerned, it's important to see what the preamble and the intent in the ordinance was provided for, and then we'll go on to the merits and the demerits of what this suspension has done. The ordinance in its preamble provides that and inter alia stresses on the uncertainty and stress for business for reasons beyond their control, the nationwide lockdown enforced from March 25th to combat the spread of COVID-19, which has caused disruption of normal business operations, the difficulty to find adequate number of resolution applicants to rescue the corporate persons who may default in the discharge of their debt obligations, to prevent corporate persons which are experiencing distress on account of the unprecedented situation being pushed into insolvency proceedings under the IBC for some time, to exclude default arising on account of unprecedented situation for the purpose of insolvency proceedings under the IBC. And these are taken as the rationale for enactment of the ordinance. Now, obviously, it was based on the objective trigger date, which was the pandemic. And from the day the pandemic was triggered, the lockdown was affected. And really, I think one of the backgrounds for this ordinance was that apart from the unprecedented and unforeseen circumstances that may push businesses into trouble, today there may not be enough interest from third-party resolution applicants in reworking these assets. And thus it was thought fit to bring in this ordinance. But what this ordinance effectively does is, it puts completely the enforcement of insolvency for a default occurring during this period into a limbo for the time being. Now, the other methods of enforcement still remain. Earlier, there was SICA, which stands repealed, Section 391, which merged into the new Companies Act, SARFAESI, etc. They remain. But what was the gravamen and real thrust behind the IBC code? And one of its intended objects and strengths was speed. Because ultimately, to preserve the value of any company and its assets, speed is the heart of it, and delay truly erodes the value of the assets of a company. Now, in this matter, pending this limbo while it lasts, the question would arise, what would happen to these companies which do commit defaults? Now, for instance, in Germany, in terms of transnational jurisdictions in recent times, there hasn't been a complete suspension. And they have not had a complete suspension, and they have said that a company would not be eligible for suspension if the insolvency is not due to the COVID-19 crisis and if there is no prospect of overcoming an existing cash flow insolvency. They've also introduced a rebuttable presumption if it is established for suspension of insolvency, that is, that no cash flow insolvent on that the company was not cash flow insolvent on 31st of December 2019. Further, for any creditor's insolvency application to be successful, it would have to show that the insolvency of the debtor took place before March 1st, 2020. The above factors in various transnational jurisdictions in Singapore, Germany, United Kingdom are completely absent in the present ordinance. The efficacy of the IBC code when it was introduced was based on certain significant departures from the past, whereby the debtor possession was substituted by creditor in possession. And the basic thesis of the IBC, where a creditor is in control and resolution professional takes charge and control over the debtor's assets, would no longer be applicable, and the rationale of the process would be irretrievably lost. That, to my mind, with this suspension, is one of the huge areas of concern for the time being. The basic feature of a creditor control is shaken when Section 10A is made applicable. The very foundation of the current avatar of IBC, some may say, is lost, and the law needs to recognize the change consequences flowing from Section 10A, and probably some arrangements may be needed for these consequences when Sections 7, 9, and 10 of the IBC are suspended. Now, we must remember that with the suspension of 7, 9, and 10, still applications under 94, 95 against the guarantors, other provisions of SARFAESI, etc., are still applicable. Now, if that is so, ultimately, if these parallel proceedings go on, are we not in some way saying that the suspension would be counterproductive to the stated object of the ordinance? Also, with this suspension, 6 months or 1 year as the case may be, would it not be a case of irretrievable erosion of the value in some of the shaky companies and would really hit the surge in bad debts in a couple of years? Now, the other issue which would have come in and does come in for consideration in these matters is that normally under Section 10, a company could itself or a debtor could itself always submit to insolvency process, and you're effectively denying that process to a company, which practically means the very freedom of exit which a company always had is today taken away, and which is really fundamental to the working of any efficient market. Now, also another problem which comes in is that any fraudulent, undervalued or preferential transaction during this period will have serious consequences, and any tendency on the part of the management or the promoters to siphon off assets during this period would further lower the realization value of the assets to satisfy creditor claims in the future. Now, one of the solicitors of a leading company made a very good suggestion in one of the papers, and he suggested that there is a need to have a bank's director or an institutional director mandatorily on the board of directors to safeguard the creditor's interest, and a law superseding some of the ordinary rights and authorities of directors during the period of applicability of Section 10A. This needs to be introduced as part of the change law so that the change responsibility of the board of directors to the creditors is documented and is enforceable. After the suspension, avenues for rehabilitation are currently only under the Act and RBI's prudential framework, which I don't think completely deals with the kind of situation that the IBC code was dealing with. Another issue which comes up for consideration is that IBC ultimately provided a lifeline to struggling companies, and the emphasis was on restoration, reviving them, then recovery. Now, what happens with this is that today, in this situation, the whole process goes into a limbo. And I think given that situation, the kind of measures which are needed is, apart from the fact that Section 10, a freedom to exit, a right to companies to voluntarily go for a reorganization, a case for directors being on the board to ensure there is no mismanagement, there is no complete debtor control, without any creditors say at all. And also possibly, although it's a debatable area at the moment because it has its own disadvantages, some form of pre-packaged resolutions to enable companies and creditors to negotiate and enable restructuring package may be considered, although that has its own critics. And they say that a pre-packaged scheme at times benefits the creditors to the disadvantage of operational creditors, workmen, etc. But something on those lines could be considered. Also, what is important is that this suspension does not address, it may take care as far as banks are concerned or NBFC are concerned, because in any case under the RBI circular, there would be a suspension and a moratorium for 6 months. So the resurgence or the emergence of NPAs during this period may be relatively lesser. But then other than this, there are issues of financial creditors or operational creditors. For instance, what happens to bondholders, where the moratorium does not apply, or in case of intercompany loans. In such cases, the amendment closes the door for initiating insolvency in cases of default. This also, to my mind, goes against the stated objective of providing impetus to the bond markets, which the BLRC report had initially provided for. Then there would be creditors, there would be operational creditors who have now little recourse to IBC. And also that issue of raising the limit from 1 lakh to 1 crore. Now that kind of a limit being raised again would have a huge impact on operational creditors, for instance, who may not have that kind of a demand due and are completely shut out in this kind of a scenario. What about wages for workmen? Because when the report came, it was hoped that it was balancing the rights of all stakeholders, and especially in the waterfall mechanism, the rights of workmen were protected. So A, with a 1 crore due, a workman is practically shut out. B, in this suspension, what does a workman do in a situation like this? What is emerging? Now, these are, I'm not for a minute suggesting that the ordinance is bad. All that I'm saying is these are concerns which emerge because the IBC as a robust legislation came with certain objectives meant to completely reconceptualize the insolvency mechanism and framework in this country, and did achieve a lot in terms of its objectives. A large amount of recapitalization did take place. Money did come in. The recoveries were exponential, as the Supreme Court said. And today, when we are suspending it, of course, in times of extraordinary times, I think some more checks and balances need to be provided in terms of, as I said, at the cost of repetition, freedom to exit. Could there be a prepackaged scheme? What about workers? What about wages for workers? What about people other than NBFCs and banks? What about operational creditors? So all these situations, I think, need a lot more considerations and attention from the government than they have got at the moment. At the moment, we just suspended. Now, would that be enough? Then, of course, there's a proviso which raises its own concerns. It uses the word ever. Now, does that mean that no default ever in this period would ever be the subject matter of a recovery proceeding? If that were so, would it be the subject matter of misuse by a company which is in control of a debtor and not in a creditor? Now, these are concerns which are bound to arise and concerns which need to be addressed. Of course, having said that, I said repeatedly, the emphasis was that, and it was said in judgments like Mobilox and many other judgments of the Supreme Court, that recovery is not the intent. The intent was revival, restoration, so that all stakeholders benefited. Having said that, that's how it started. But there has been a certain amount of misuse also, I must confess. There have been a lot of cases which have just been meant for arm twisting, blackmails, where companies have been forced to settle, and which were really nothing but recovery disputes brought in the garb of resolution. So there, probably raising the stakes did have its salutary effect, but it does have an impact, as I said, on many other sections which need to, like operational creditors and workers, which need to be addressed. And to some extent, yes, it had become a recovery proceeding, and that malaise which had crept into the framework needed and needs to be addressed, because that was never the intent, and the intent was always to revive the company. That's the first option, because naturally, every stakeholder benefits. In the long run, the operational creditor benefits, the financial creditors benefit, the workmen benefit, and we've seen it in a number of cases. In many, I've had the privilege of appearing, where there's been a dramatic change with the new management coming in, the creditors having been in control during the period when the moratorium existed, and that did change the color and the way the companies were run. The other issue which has arisen with this suspension has also been an issue which also arose in a case in the Chennai High Court, and then also in the Kerala High Court, which I think pertain to the judgment in Aeroline, if I'm not wrong, versus Rockwell, and then a Calcutta High Court judgment in Fusesco versus Boseco Rail Products. Also a similar issue arose, that where the judgments were reserved, applications had been filed on time. Could, with the new regime being triggered in, would the new raise in limits apply? And the courts, to my mind, rightly held that they would not, and they would be guided by the regime as it stood, because there was nothing, they were all prospective in nature. But they were simple answers, and I think there may be more complex situations which may arise in future for something like this. And ultimately, I think it will reach the Supreme Court, and the Supreme Court will have to answer this question. Of course, one straight legal answer with these two judgments, I don't think, subject to correction, I'm not dealt with, is the first point, that on the date of institution of any legal proceeding, what is the existing legal regime? And that ordinarily, until and unless a statute comes with a retrospective operation, is the legal regime which prevails and covers any proceeding instituted which is prevalent on that particular day. So now, these are my broad thoughts on the various issues. Prepackaged deals, as I said, still have their critics, especially in a country like India, where they say where IBC is still at a nascent stage, it would be too drastic a measure to bring in. There are critics who say that that prepackaged schemes do not enjoy the moratorium, so simultaneously it doesn't stop the creditors and others from initiating proceedings. Another major criticism of the prepacked schemes is that it's more in favor of secured creditors, and neither do operational creditors have much say in the negotiation, nor do they are given a fair share. They also say that transparency is a big hurdle, and then 29A would also possibly have to be amended if prepackaged schemes are to be brought in. So, but nonetheless, they deserve attention from the government and from the experts in the field, because in some form with checks and balances, it may not be a bad idea. So to my mind, probably the suspension was needed in the extraordinary times we are in. But as suggested, I think it should not be left entirely to the control of the debtor, because that was one of the fundamental policies of IBC, that either a resolution professional or a creditor control in some form came in. So possibly, as was suggested, some directors on the board, some form of control, some checks and balances on where the money is going, transparency, it's not being siphoned off. Definitely, Section 10 should not be discouraged, should be restored where a party wants to freely exit. Some form of attention to prepackaged schemes could also be given a thought to. Better protection of rights of operational creditors, workmen in these situations needs to be looked into. And also the raising of this limit, should it apply to small operational creditors? Should it apply to workmen? Should also be given a thought to. Those are my broad thoughts on the entire scheme, and as the amendments have been brought. And I now welcome questions on the issue. I think that'll make the thing far more interesting. Thank you, Naveen. Naveen? Can you hear me? No, I can't hear you, Naveen. Yeah. Yes. Naveen, I think I'll be happy to take questions. I've given you my broad frame of what the suspension, the problem, the positives are, and I'll be happy to.
Great. Varsha, you can start questions being open to the chat window. Before that, sir, I would just like to get sir's perspective on a few things.
Yes.
Sir, this date of 25/3/2020 is being declared to be the crucial date.
Right.
And if at all, for a default that occurred on 24th, an application can be filed. Right. On 25th, an application cannot be filed.
Right.
Do you think, is there any rational basis for this distinction?
You know, strictly, Naveen, if you go by what you're saying, it will be found wanting on any rational basis, because let me put it, right from mid-February, the strain on the economy had started. And also the last 3 years have seen an economic slowdown. It so happened that the lockdown happened on the 25th or the 23rd, whatever. But the companies were reeling under an economic slowdown for the last 2 to 3 years, and the last year in particular had been particularly bad. And the latest figures on GDP which came out showed that de-horsed the lockdown, the GDP wasn't doing, the growth in GDP wasn't doing too well. So one of the arguments which could be taken is why should we not be covered as well? Why only the pandemic situations and not us who were reeling under our economic slowdown? Having said that, in every case of a legislation or an ordinance, very often there is a cutoff date. And courts have also said that at the end of the date, there will have to be some cutoff date for many situations to arise. And that cutoff date at times may be inevitable, because suppose you were to put it as 1st of February, someone on 29th of January may say, look, I'm also reeling under the economic pressures. So I think that would be a debatable issue. But yes, you're right. I don't think the economic woes of the industry started just with the lockdown. According to me, they got speeded with the lockdown and became far more acute with the lockdown. But according to me, the industry has been suffering now for various measures. I think personally, if you ask me, I think the government has to be a lot more dynamic and robust in coming out with economic measures and with solutions. So, and the company has been crying for these reforms for a long, long time. So a lot of industries could say we equally need this. And
Yes.
our insolvency is not the product of our mismanagement. Our
Yes.
insolvency is probably the product of government policies. There may be many industries which would say that. To answer
So there are
your
a couple of questions that have already started coming. It's a quite interesting questions. There is one question from Mr. Yashwant, where he asks that now that the suspension has come into force, should the increase in the default threshold, that is the March notification, be rolled back, or should both these protections coexist?
You see, as I've expressed my views in my opening also, to my mind, this, when it started, the purpose, as emphasized again and again in IBC proceedings, was not recovery, but revival. But somewhere, I think it did acquire arm twisting tactics. And in a large number of cases, it did become a recovery proceeding under the garb of a insolvency proceeding. Now, there, I think more than anything else, this increase did have has a salutary effect, because it does exclude a certain number of cases where you just drag the company for nothing to court. Having said that, the increase also has its problems, because it doesn't address the concerns of workers. It doesn't address the concerns of small operational creditors. And very often an MSME, maybe a small operational creditor, who may be supplying goods, may not be meeting that threshold of 1 crore. So according to me, even the categories which are covered by this increase, that is 1 lakh to 1 crore, need to be revisited. It may be continued to answer your question along with it for certain categories. But for certain categories, I feel it needs a relook and a second look as to it may need to be rolled back for certain categories.
So that's exactly the question that Mr. Sanjay Mahalingam has put regarding the MSME. Because as sir would know, MSMEs, they might have probably supplied or provided services for 40 lakhs or 50 lakhs or even 60 lakhs.
Absolutely.
That's going to be onslaught.
Yeah, that's what I said. These things, look, Naveen, as I said, I'm not trying to be wiser by hindsight. I can understand the predicament of the government also. These were extraordinary times. Everyone, you say, do something. So there were some immediate measures, but at times some knee-jerk reactions also come in. The way governments react, some are very well thought of decisions, but some are not so well thought of decision, or possibly, if we give them the credit, they didn't have enough time to think them through. But nothing stops the government from thinking them through. Something can be improved, fine-tuned, things can be added, things can be deleted, and I definitely feel the raising of this threshold to 1 crore, especially for smaller operational creditors, especially for workmen who otherwise under the waterfall mechanism have a certain position in there, need to be revisited, at least for these two categories.
Thank you, sir. Sir, there is one more question. With regard to arbitration proceedings and civil suits, once if it's open, the option is open. Once I file a IBC proceeding and the matter is pending, and I of course use my other hat and file this, what will be the impact on that? Because now IBC stands suspended. So my civil law remedy is always very much open. So if I use it there, is there any predicament that I would suffer?
Yes, according to me, for the time being, if you think in the larger scheme of things, at the end of the day, it may be counterproductive, because tomorrow, if it starts, the IBC proceedings start. What do? You have parallel proceedings going on there. That's one part. Secondly, please look at it this way, that even earlier, you had SARFAESI, you had SICA, which has now been repealed, you had Section 391, which merged into the Companies Act, you had all that. They were obviously not found to be very efficacious remedies, and all these decades of all these proceedings under DRT, SARFAESI, etc., but definitely not as effective as this IBC legislation which came in. This was a far more comprehensive legislation for revival of companies. So to my mind, you're absolutely right. There is bound to be a predicament when these proceedings are started, because there's no embargo on them. And even when we get back to the regime, I don't even know. There are people who've thought that it may be actually counterproductive till a point to have these proceedings. Then Sunday, the insolvency proceedings revive. There may be huge issues on this 1 year from now.
So there is one interesting question from Ms. Sripriya Kumar, where she asked, the change was also possibly to prevent gaming of the system and enterprises being bought back at extremely depressed prices, which would have enabled bankers to write off huge debts under the garb of resolution plan and liquidation. What alternative safeguards could have been built rather than this decisive ban? So she's basically asking the question that, of course, I leave it to you.
No, I think, Madam, you're absolutely right. In fact, in my opening, I said so, that the preamble to the ordinance itself talks about one of the principal reasons for this ordinance was that either there may not be enough people to buy it at its real value, which would result in hugely undervalued values at the moment at which people may pick them up, doing great damage to the debtor in question or the company in question. So that was one of the guiding factors in this behind this ordinance. But having said that, amongst the suggestions as I made in my opening were that quite apart from that, this was possibly needed in some form. But as I said, in terms of the interregnum in management, to me, some of the principal concerns are the fundamental thesis or ideology behind the IBC code from the time the moratorium is triggered is creditor control or a resolution professional control. And we know that has been by and large better for the company than the debtors who are responsible for grounding the company to dust being in control. So there was more transparency. When the debtors are in control, there's lack of transparency, relative transparency. There's danger of siphoning off, etc. Not to say there haven't been problems with resolution professionals. I'm conscious of that. Even we've seen problems with resolution professionals while handling these companies. But by and large, one of the principal fundamentals of IBC was creditors being in control. So my immediate suggestions is that the ordinance may stay or should stay, should along with it have creditor representatives on the board, some say in the decision making, more transparency, more control on how the affairs are managed, where are the funds being diverted. Secondly, in any case, the freedom to exit under Section 10 should still be available to companies. They should be allowed to exit if they want to from the companies. That is another measure which is immediately needed. Thirdly, maybe in a far more refined form, a prepackaged scheme can also be looked at in the given circumstances, coupled with the threshold being revised for workers and operational creditors. These would be the immediate methods, measures, according to me, to answer your question, to continue with the ordinance and yet bring in and fine-tune the ordinance with these suggested changes.
So there is one more question by Shri Murari, Senior Advocate of our High Court. Mr. Murari has pointed out, as you rightly pointed out, if proceedings against the company are not to be instituted, would it not be unfair to corporate guarantors of proceedings can go on against them?
Yeah, in fact,
yes.
Naveen, good morning, Mr. Murari. I said so again in my opening that don't forget, although you've suspended 7, 9 and 10, but under 94 and 95, I think, of the IBC, the guarantor proceedings can go on, arbitrations can go on, SARFAESI can go on, debt recovery proceedings can go on. So as far as the guarantors are concerned, they may also say tomorrow that, look, in the same set of circumstances, you're suspending proceedings. Why should we in the given scenario be proceeded with? That's a very legitimate concern.
Thank you, sir. So there is one more question. Of course, not to sound too pessimistic, there is a question that asks, will IBC become like DAFR or SICA?
I hope not. and as to again use the words in Swiss ribbons, where the Supreme Court said the defaulter's paradise is lost, in its place the economy's rightful position has been regained. I hope we don't lose this regime and mechanism. I think it will be a pity if we do that. And that's why I said, Naveen, very often we have knee-jerk reactions. I'm not saying this was a knee-jerk reaction. I'm saying very often governments have a tendency for knee-jerk reactions in dealing with situations. I think we need a far more nuanced approach. We need a far more mature approach to it. I think IBC is an excellent legislation. Frankly, a lot of problems with IBC, with great respect I say, came not from the IBC, but with the working of the IBC.
Yes, yes.
And I have always blamed, I think the tribunals have been hugely responsible for this. In fact, we every day, day in and day out, appear in the Supreme Court in IBC matters, and it has ultimately been the Supreme Court which has restored the position, has remedied the wrongs committed by tribunals at various levels. So the IBC, of course, every new legislation needs to be fine-tuned. It may have had some problems that need to be amended, Broadly, it was a good legislation. It was the working of the IBC which had problems, not the statute, as they say about the Constitution of India also.
Yes, sir. So there is one question from Sri Om Prakash, senior advocate, where he's 1 second. The question that's of Sri Om Prakash, senior advocate Madras, is that no default after 25th of March will not qualify for initiation of action under the IBC for the 6-month period is set from the ordinance. So is it that from June to December is the 6 months from default from 25th March? Can it be said that an NPA account with a bank in a first week of March can still be subjected to action under the IBC post-COVID? Sir, this one I would follow up on a question with this, which I have. Sir, now as you, sir, rightly pointed out,
you just explain this question a bit more. I haven't understood the question.
Sir, I think what an account that has been classified as an NPA in a bank pre 25th of March, can we still proceed after the 6-month moratorium is over?
According to me, yes, because the ordinance says any default during the post 25th for 6 months or 1 year, whatever the case is. Yeah.
Sir, one other question that troubles us, which I think, as sir said, will reach courts, is the word used with the proviso is no application shall ever be filed.
Yes, yes.
Does this mean that, for instance, there is a default for this 6 months period, an application cannot be filed? Of course, it's known, it's common parlance. Or is it an indication of the parliament that for the 6 months, whatever defaults have occurred, at no point in time a proceeding can ever be filed?
You know, Naveen, at the moment, it's very well capable of the interpretation ever as it stands, until unless ever is read down or is given a more purposive construction in tune with the ordinance and the IBC code. But a literal construction of ever is ever, forever. So according to me, that does have its own share of problems. And as I pointed it out in my opening, that the concern of that would be there could be misuse. They could be used as a time to siphon off, do many other things, and use that as a time that no one will ever proceed against us. So ever has a huge problem with it and needs interpretation, according to me, because a literal interpretation would mean it would be never subject to an IBC proceeding.
So there is one more question from Mr. Dhanapal with regard to fast-track insolvency being completely absent in the ordinance, and also that individual insolvency as guarantor also has not been addressed. Can action be initiated against guarantors?
Both. On the first point, as I mentioned, speed is at the heart of IBC. Why is it at the heart of IBC? Because delay erodes value. And the object of IBC has always and must be to restore a company on its feet at the earliest. And that is why a well thought out time frame was provided therein. Now, the moment I'm not for a minute saying, as they say, justice hurried is justice buried, but at the same time, I think it was a reasonable framework and time framework provided under the statute. And that is absolutely imperative, because without it, you will completely destroy companies, and not only companies, any resolution applicant who commits to invest money, in turn organizes loans, in turn organizes funds, he cannot wait indefinitely, nor can financial creditors wait indefinitely, and neither can company wait indefinitely. Naveen, I can tell you from personal experience in any number of matters where every conceivable tactic was used by the debtor, from the corporate debtor, of delaying proceedings in any which way they could to ensure that the resolution applicant is exhausted and comes to the negotiating table or backs off completely. In any number of cases, I've seen that. And that is why I said at times the working of the IBC by the tribunals has been a problem, because those delays were occurring because the tribunals were permitting those delays to occur. And so speed is of huge importance. And the second part of the question was about guarantors. And I said so. I said that will be an issue, that the guarantor tomorrow can turn around and say, look, I'm a guarantor. Okay, it's an independent guarantee. It's independent of any underlying contract. We all know that. Those are the law on any guarantee which is given. But the fact is, in reality terms, it is related to the debt of the corporate debtor. So it would be a legitimate concern and a question, why am I being proceeded against when under section 7, 9 and 10, The company is not proceeded against.
So there's one more question from Mr. Mahadevan, which is, I think, quite just a follow-up of what we say. I think there is an article also written by a lawyer from Chennai, sir. For instance, there is a company, I've taken a loan, say for 2 crores, and I have a repayment of 20 lakhs per month. Say, for instance, it starts from March. So March, April, May, June, July, or whatever 6-month period, it accumulates up to 1 crore. And after the 6 months, the 7th month, I'll have to pay 20 lakhs. Yes. So it should be calculated as I should pay only the 20 lakhs, or will it be 1 crore and 20 lakhs? So can I still initiate after the 6-month period? I think it's just a follow-up. So can I still initiate for the non-payment of the EMIs or the loans that ought to have been paid?
You see, as far as EMIs and loans from NBFCs and banks are concerned, it's only a moratorium as per the RBI circular for 6 months. Neither is the interest as on date. The Supreme Court is seized of the matter, but as on date, there is neither a waiver on interest or the fact that the loan gets reduced. So the only thing that happens is the NPAs during this period will be less. But at the end of it, the liability to pay doesn't get waived. So if the liability doesn't get paid, it accumulates at the end of the day and will become the basis of an insolvency proceeding later on.
So there is one question with regard to what are the steps that can be taken by the IRP for distributing the assets in this lockdown period. For instance, sir, once when the resolution plan is approved and assets are to be distributed, in this lockdown period, some companies or people, those who have been creditors, they would be in so much of need for funds. So what do you think? Do you think that IRPs will be in the usual gung-ho for distributing assets, or will the delay be fatal?
A distribution to whom? To the resolution?
Yes, sir. Under the waterfall mechanism, the distribution.
I see. No, according to me, that should go on for the simple reason that people who had to be protected have been protected with the suspension. Anything, what you're saying is reference to anything which had happened before the lockdown, right? Am I right there?
Yes.
So that's the kind of cases which the distribution will apply to. The distribution will not apply for this 6-month or 1-year period or a default occurring during this period. So for those, according to me, it should go on because Naveen, we must understand these are problems where every stakeholder's interest must be seen. There are all kinds of cases coming. At times people rush to say, don't give us, don't take money from us. On the other hand, there are cases involving, for instance, mutual funds. Mutual funds have a stand. There have been those litigations pending, going on, etc. There are other litigations which were decided where some NBFCs said that the mutual funds in turn shouldn't take money from us and the moratorium should apply to mutual funds also. The mutual funds in turn turned around and said, look, it doesn't work that way. We have unit holders. Unit holders come to us. The difference is stock in fees and there are stakeholders. So if the person who has taken loan needs time, the person who has given loan also needs money. So to answer your question, you can't have a perspective only one-sided. In this, you have to look at all stakeholders. And that is why processes which were going on, according to me, under those processes, the resolution professional should continue with the process and it should lead its logical conclusion, including the distribution of assets. Because otherwise, you will bring that to a grinding halt and a huge set of stakeholders will suffer under the garb of the pandemic. See, pandemic is an extraordinary situation. Doesn't mean you'll put all liabilities, obligations in suspension. That's not the purpose. Things must go on. Processes must go on.
So there is one more question that on a personal note I wanted to ask. I think almost the same sentiment has also been resonated by Ms. Sripriya Kumar. Yes. So as you know that under the Commercial Court Act, we have compulsory pre-mediation. Under 12 years.
We have.
Under the Commercial Courts Act, pre-mediation, sir. Pre-mediation yes. Under the Commercial Court Act.
Yes.
Would have something like that, saying that some pre-mediation with a moratorium of 3 months or 4 months, been a better resolution with extended timelines than the complete suspension?
As I said, today we all have the hindsight benefit of what happened. I can understand in the times and situations when it happened, but definitely to some extent it's a knee-jerk reaction and it requires a lot of fine-tuning. What you are suggesting as a pre-mediation can definitely be built into this. You can have suspension, pre-mediation. I think it's a very good suggestion that you're giving. It could definitely be built into. the whole thing with the recommended changes that I'm suggesting or others have suggested.
So there was one question from Vasanta Kumar Venkatesh where he asks about lawyers being appointed as IRPs. But I think lawyers, once when they qualify the exam, there is no bar for them to be appointed.
Right. I think so too. Yes.
So, and another pertinent question, sir, that's been troubling. I think it's an issue that you pointed out. What will be the impact of pre-packaged deals in this context? Assuming we are going to, because the government, in a way, I think to be honest, if sir can agree, that we said too many cooks spoil the broth. The amendment that was allegedly proposed, which we saw in the news sometime in March or April, and what has come through seems to be completely different. Are they trying to satisfy multiple stakeholders in that process? Have they created a messy situation?
You know, at the moment, we don't have any amendment as far as pre-packaged deals are concerned. But at one level, it avoids the whole insolvency process. You have, without going through the litigation, going through the time wastage, you have a ready solution. On the other hand, it has its fair share of criticism. And the starting point, of course, is that India is still at a very nascent stage of IBC law developing and the mechanism developing. And it would be too drastic a change to bring about immediately. The other concern is prepackaged schemes don't have the moratorium shield, and people could proceed with the creditors could enforce their rights and remedies wherever applicable. The other criticism, and that's a serious criticism, is that it's more in favor of secured creditors, and neither do operational creditors have much say in the negotiations or are given a fair share. Transparency also, in case of prepackaged schemes, is supposed to be a big hurdle, since the existing management would be in charge of alienating the assets of the company. And then Section 29A would also have to be amended if the prepackaged schemes were to be brought in. So they would, as far as prepackaged schemes are concerned, there would always be those apprehensions about correctness of the entire process. And this may lead to unsecured creditors, operational creditors, workmen, etc., being left highly dissatisfied in the scenario that we are in.
So there's one, I think we'll take last two questions. Sir. One question is from Aravind, where he says, what will be the impact of insertion of subsection 3 to section 66, which gives undue protection to a director of a corporate debtor? Can the directors of corporate debtor walk away scot-free just because fraudulent trading happened during the period of application under section 10 of 10A? Would like to know your opinion, sir.
No, according to me, no one should walk away if it is a fraudulent transaction. Because as you know, even a decree obtained by fraud is a nullity in law. And yes, fraud vitiates everything. So if fraud vitiates everything, whether it is a suspension or not a suspension, according to me, if fraud is established, there can be no immunity of law to a fraudulent transaction. No law will ever say that irrespective of a fraud committed by a person, we are absolving him of the fraud. That can never happen. Fraud vitiates any protection.
So I think one interesting question that Mahalakshmi has raised. In fact, yes, I also wanted to just, I think sir would know of the Supreme Court matter where compulsory wages has to be paid according to the Home Ministry's notification is pending. And the Supreme Court recently has said, why don't the employers and the employees sit down and negotiate? So now the question that Mahalakshmi has raised is one thing, sir, she says that will it not lead to the employees being eventually becoming insolvent? And the other question that she raises
Naveen, I'll interrupt you. That's a question I would not. Yes,
I understand. So, and do you think this overcharging of interest by banks at a later point in time should be curtailed? Should there be any measures that so that in the end of the lockdown period they do not come like a tiger pouncing on us?
No, overcharging and what is legitimately due as interest are two things. Overcharging under any circumstance, Naveen, will not be permitted.
Interest
on interest would be the same law which governs the position even today otherwise.
Yes. So I think we'll just take one last question, sir. Thank you very much. There is one question by Mr. Dhanapal, where would ordinance also extend to all such companies who are given corporate guarantees before the earmark date of 25th March, but upon invocation after the said date have failed to perform their obligations towards such corporate debtors, and therefore would they enjoy the protection of 10A in this regard?
No, so is the question that the invocation was before, but the default was during the lockdown?
Yes.
Is that the question?
Yes, sir, yes.
Now, again, there'll be arguments and counter arguments. If I was appearing for the defaultee, for the defaulter, I would say that the default actually occurs during the lockdown, and the ordinance makes no distinction between the two. Going back to your judgment, which the Chennai High Court utilized in a different scenario, the counter argument could be that the law on the date it was invoked would govern. So as I said, these are early days and these are interesting questions which will go in for adjudication at some stage.
In a lighter way, may I say that most lawyers practicing in IBC feared that their practice will be doomed for 7-8 months. Is this ordinance going to pave way for more litigation for us, sir?
Well, Naveen, even when the IBC came in itself, it was such a boon for lawyers. And as you said, with every legislation which comes into this country, including arbitration, just on a lighter vein to answer your question, when the Arbitration Act came, I heard so many people in 1996 saying this would be the death knell of litigation. Arbitration will take over. See, from then till now, it's been 24 years. Litigation is booming. Lot more litigation has been created than there ever was. And the smallest of interpretation, from deciding whether appointment of an arbitration was a judicial function or an administrative function, to it being reversed. I think courts ensure that lawyers are kept fully occupied.
Thank you very much, sir. So thank you very much, sir. It was quite an extremely great perspective that sir has given. And as Insolvency Bankruptcy Court, as sir points out, this amendment will open a can of worms. But time has to answer. Thank you very much for the insight, sir. It was such an engaging discussion. And it will be evident from the number of questions the participants have put forward. And in fact, even after I finished it, there are questions coming. Thank you very much, sir. It's been an honor to have you today. Thank you very much.
Thank you very much, Naveen, for inviting me. And thank you very much to this very distinguished audience. Thank you very much.
Thank you very much. Thank you. Take care. Thank you.
Thank you.